Welcome to U.S. Immigrant Journey, Opportunities and Challenges.
Hello, everyone, and welcome back to U.S. Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogam. Edwin is the founder of Fogam and Associates and has spent nearly 3 decades helping immigrants and their families navigate the U.S. immigration system. My name's Sean O'Connor, and today Edwin and I are talking about how family-based immigration works, from sponsorship to timing to what families can realistically expect along the way. Important topic. I love this idea of, bringing family members in. Can you explain who's allowed to sponsor a family member for immigration into the U.S.?
Yes, of course. Well, first of all, when you're looking at family-based immigration, you have to differentiate it from, just to understand it, differentiate it from employment-based and humanitarian, employment-based for skilled workers and so on. But generally, family-based immigration, when you think of that also, you should think of permanent residents in the United States as well as citizens of the United States who are foreign nationals who originally or foreign nationals. So permanent residents can file petitions for their spouses and their children. U.S. citizens can file for their spouses, parents, children, and even siblings. So this is, first of all, a big difference.
Got it.
The second difference is that the petition can be filed within the United States, or rather, it can be filed in the United States for the family members to come from abroad, or it could be filed for family members who are in the United States to adjust their status in the United States.
When you talk about these processes, does it change? I mean, there must be probably some subtle differences between, let's say, the sponsor is a U.S. citizen versus someone who maybe is a green card holder.
As I said, a green card holder can file for the spouse or the children, but there is also a priority date, a waiting time for green card holders when they file for their family members, whether to come from abroad. U.S. citizens who file for their family members, the family members are considered immediate relatives, in quote. That's parents, spouses, or children below 21 of U.S. citizens. There is no waiting time for those categories of foreign family members.
What's the waiting time typically? Is it a set period or does it depend?
This depends. It is the U.S. State Department Visa Bulletin publishes every week various categories of visas, because visas are issued every year for different categories, from employment-based to family-based and so on. And the State Department actually publishes the number of visas that are available for that year and how they are being used. So after your petition is filed, if it is one of those preference categories or non-preference categories where you have to look at a visa currency, then that has to be followed. But if you are a U.S. citizen filing for an immediate relative, those visas are always available and they don't fall within those categories. So that is usually a little bit of...
I mean, it sounds like we've got categories within categories, because you've got different types of, you've got the categories of family-based immigration is a category. And then within the family-based immigration category, there's a structure, right? In terms of how someone is categorized.
You hear things like F1, F2, F2B, F4, because it would be child or parent or sibling and things like that.
Talk about the key differences, right? You mentioned, you can apply from inside the U.S. versus going through the consular processing abroad. Is there a big difference?
Yes, there is. There is a very big difference. First of all, if for the green card petitioners, those who have permanent resident status, because during the waiting time, when the visas are not immediately available, they cannot do any adjustment of status in the United States or from abroad. Now, U.S. citizens can do either adjustment of status in the United States if their family members are here in the United States, and their immediate relatives who had entered with inspection. In other words, they had been admitted, even if they are out of status, but they must have been admitted. As opposed to that, if their family members are abroad, they have to file an initial petition called a Form I-130, and unless and until that petition is approved, the family members abroad cannot come in. But once that is approved, the next process is the consular processing that you mentioned, and that is the State Department. The petition is sent to the State Department, and the State Department will contact a consulate or the embassy abroad, and the foreign national will go for an interview and can come into the United States as a permanent resident. So those are the differences.
Yeah, different. I mean, timing in this stuff is always a topic, I know. Are there main reasons why, some families wait much longer than others? Because, I mean, you mentioned one there where, inside versus, consular process versus.
Yes, it also depends on the country. Different countries have, countries have different wait time, because countries like India, the Philippines, they have for preference categories, they have long waiting times. Of course, as you can imagine, they have more applicants and petitioners from those countries. So the cutoff for them is wait time is long. But as I said, if they are immediate relatives, if the petitioner is a citizen of the United States and the beneficiary is an immediate relative, that is a parent, a spouse, or a child below 21, then there is no waiting time.
What are the most common issues that you found? When a case hits a snag, right? What are the common complications that you see?
Two big common complications: establishing the bona fides of the relationship, the good faith of the relationship. For parents filing for children, or children filing for their parents, that is not too complicated. It can many times be established easily. But for spouses filing for their spouses, there is something called a good faith marriage, right? You have to establish not only that you are married by certificate or something, you have to establish that you have a shared life, you are in a good faith relationship, and you are not entering into this marriage or filing this petition to circumvent immigration laws.
Yeah.
It is very strict, and sometimes it can be a high burden if the couple do not have children, they don't have children, or if they don't have substantial documentation of a shared life. And you can imagine somebody filing for their spouse abroad. The initial I-130 can be approved easily because person is abroad and a lot of documents may not be required. But when it gets to the consular processing and the interview, a lot of questions may come up as far as the relationship is concerned.
Yeah, I mean, I want to say, like, we've seen this TV show or this movie before. Or just, you hear about it in popular culture where, so-and-so wanted to emigrate or get a green card, and so, they created, they maybe did get married legally, right? They got married, but it's almost like only for the purposes of and so they don't really have any shared life. And so you think about those, what's your husband's favorite food? Or, like so. Exactly. I mean, I'm being a little ridiculous there, but they do try to detect those relationships of convenience, I'm guessing.
Yes, USCIS is very strict about that, and the immigration laws actually provide that if you enter into a sham marriage, a marriage that has been determined to be a fraudulent marriage, you are permanently barred from any other immigration benefit.
Is there what the penalty was? I mean, is there a financial? Is there a fine, or you just you just can't?
No, it prevents you from ever getting any immigration benefits. Not only the marriage petition, but any. So
and so if you're already in the country on a visa and you create this sham, they'll kick you out and you can't come back.
Exactly. Yes. Wow. And even
Okay. All right. So now, I mean, on the other side of that, people that are honest, they're on the up and up. What does a well-prepared family-based case look like from the beginning for you? Because I know you're building these cases all the time.
That is it's a very important question from just based on what we have just mentioned. First of all, of course, there has to be a valid marriage proven by the marriage certificate. But in addition to that, even if you have not obtained documents of joint assets and liabilities yet, you have to have some evidence of a shared life, right? Sometimes you may just have gotten married without having lived for long, but have you been communicating? Do you know your families? Because during the interviews, they will ask you personal questions about your relationship, what you know about yourself, and other things you've been doing as husband and wife. Do you communicate if the beneficiary is abroad? Do you communicate? How do you communicate? By phone, text, and things like that. So many times there are no specific requirements or list of documents that you must provide to show that it's a bona fide marriage. But there are things that are expected. And once that is done, once we establish that it's a good faith marriage, then the process can move very fast. You file the I-130 petition. If you're filing it concurrently, you file with adjustment of status. Or you just file the I-130, then the consular processing.
We spoke about other pathways to citizenship in a different in a previous episode, and we were talking about like recommendation letters, right? Like from peers, or I'm wondering in this family related, would you have your clients get a letter from a neighbor or someone that knows that, oh no, these two people, they're definitely married, even though, he's here and she's there. Does that come into play where you would have a witness, so to speak?
You got that right. With, of course, the affidavits, sworn statements of family, friends, colleagues who know you as a couple and who have interacted with you. Those can be very helpful as additional documents and information. You are right. That's true. We use that. We use affidavits all the time. In our list of requirements and general documents to be submitted or to be brought to us to review, we have those all in there for clients to consider.
I'm sure you're having to manage people's expectations in this process, and people have different priorities, or certain dates they're trying to get things done by. How do you help families stay realistic about timing? Like how long this is going to take, but you still want to put them. They want to be in a position that is advantageous, right? To getting approval. How do you manage that with your clients?
It's very important because these days USCIS processing time, they can really be unpredictable depending on how many visas or how many petitions or applications are being processed at a certain time, and because of other immigration issues. So we always advise our clients, you look at your immigration strategy very broadly. Depending on your current status in the United States, you have to look at what are the next steps or the possible obstacles if you have to live here, stay here long enough. Fortunately, many of these petitions, when you are in the United States, you get a work authorization, an authorization to work and wait while the petition is pending. That can be very helpful. Sometimes, depending on how you enter the United States, you can even have a travel document from I-131 to travel back and forth while your case is pending in the United States. Now, for those who are abroad, it will depend on whether your petition is filed by a permanent resident or by a U.S. citizen. And again, as I said, the visa bulletin, the number of visas available, the priority date, that is the date your visa will become current. We have to look at that and advise the clients accordingly and let them know. Sometimes we show them how to look at their visas availability in the visa bulletin, and that really helps. And even processing time, they can go to USCIS.gov sometimes and check their cases and see the processing time. That will take off a lot of pressure from us. Yes.
Yeah, just that I know a lot of it is that not knowing, right? You know, I mean,
Exactly.
it's okay, it's going to be 2 years. I'd rather know that than not
Yeah.
know, even
Then,
though 2 years is a long time.
yeah.
Then also that, that idea that, okay, if you're here in the States, that you can, if it's in process, you can get permission to work. You can get, work authorization, or if you need to travel during the process, you can come and go. So that's got
Exactly.
to be a big relief for a lot of people.
When they know that, when clients know that, as you rightly pointed out, a little bit of predictability is important. When they can at least have an idea of how long it's going to take, and we can always estimate and give them some reasonable estimate of how long it's going to take. Although caveat, we always let them know that things can change because USCIS can change the processing time and things like that.
I used to work with someone, a client in a consulting business, and they used to say, it takes as long as it takes.
That doesn't help, right?
No, in the immigration world, bad. But I was I was saying, hey, this is going to take longer because of work order changes, and they were very nice about it. They're like, well, it will take as long as it takes. Like they were very comfortable with the time ambiguity. So I'm just curious, before we sign off, is there, because I know you're working with families all the time, is there a case in particular that stands out that you helped move through the process, and something in particular made it successful, that you want to share?
Oh yes. Oh, for family immigration cases, that is a lot. There are lots of cases like that because there are many cases, especially cases where family members here are filing for their beneficiaries or their family members to come from abroad.
Yeah.
We have cases here. I mean, more than 2-3 cases that are just ongoing. That even though there is a visa pause in the consulates, their petitions have been approved, and some of these family members are coming from countries that are really in a very bad situation.
Yeah.
And their petitioners have
Like
lived here for
complex.
many years. Some are children,
Yeah.
young children, who are coming here to go to school, and their families are here. But I have always been thinking of some of the cases where after have filed for some family members to come to the United States, and after many months, some of them who come, or after the kids come into the United States, they'll bring their children to the office and tell you, here they are. Sometimes they come after years, 2-3 years. The kids are already in college or something like that. So
Yeah.
those are the type of cases. Yeah, we get those type of cases a lot.
Well, thanks, man. Edwin, great to talk to you as always. It's always informative and just enjoyable, and I look forward to talking to you again soon.
Thank you very much, Sean. And as I always tell all my clients and potential clients, don't fear the system, understand it, and work with it. You may benefit from it.
Well said. Well, that's it for today's episode of U.S. Immigrant Journey, Opportunities and Challenges. If you're looking to bring a loved one to the United States, or you want guidance on your situation, visit Edwin's website, fogamlaw.com, to connect with Edwin and his team. I'm Sean O'Connor. Thanks for listening, and always, don't forget, leave us a review, share a link to the episode with someone you know that's looking for help with their immigration status, and we really appreciate it. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.